Listen, sir, don't get smart with me because, you know, it's 93 days in jail waiting on your head. I can just let you do that instead of paying, but I'm trying to help you out so you can get a valid driver's license.
That's not an answer, sir. Your name is either Ryan John Hart, in which case you're invited to participate in the proceeding today as Ryan John Hart, or you're not Ryan John Hart, in which case I have no use for you to be in this hearing today. Not an argument. This case will not proceed by me talking over you or you talking over me. Court proceedings, by law and by procedure, Mr. Hart, are to be ordered. And they're to be in a specific order. And
City of Detroit versus Rico Gator. Case number SP 128-1837, counts 1 and 2. SP 156-07261, SP 162-4983, counts 1, 2, and 3. SP 164-3083, counts 1 and counts 2 in the state of Michigan versus Rico Gator, case number SX 40380982. Appearance for the record, please, Mr. Barry.
Elwood S. Berry Jr. on behalf of the defendant. State your full name, Mr. Gator.
I'm speaking for the corporation of Rico Gator.
They're gonna love this one. Good morning to you, Mr. Gator.
Good morning.
All right, today is the date and time. So I kind of got to get an understanding of, we need Mr. Rico Gator. We don't need the corporations of Rico Gator. How do we find Mr. Rico Gator?
I guess that's the name I was given. I guess I'm Rico Gator.
Okay. All right. Today is the day. Now, let me ask you this. Do you want Mr. Barry to represent you, or do you want an attorney to represent you?
Yes.
Okay, good. All right. So today is the date and time set for, it's some matters under warrant status, Mr. Berry, and other matters are in pretrial for the purposes of the warrants. Mr. Berry.
We would waive the reading of the information and stand mute.
And we'll enter a not guilty plea on your client's behalf and give your client a $0 bond. So what I have here is 1, 2, 3, 4 tickets in Mr. Gator's name, and then I counted some other tickets into the record. I can give you those tickets whenever you're ready.
Ready, Your Honor.
I have a driver's license suspended. I have a no insurance misdemeanor. I have a no ops. I have a failure to stop and an improper turn. So it should be 1, 2, 3, 4, 5, 6, 7, 8, 9 cases I called into the record.
Yes, Your Honor.
2 of them are civil infractions that were in default. I have no problem setting these defaults aside. They were kind of a little bit back in October, but since I just said it, I don't have a problem setting an improper left turn and a failure to signal at a stop sign or whatever that is, if the city has no objection to hearing you.
No objection, Your Honor.
Give Mr. Gator an updated offer. I also see a no insurance, the insurance no proof 288. If Mr. Gator is interested in getting a valid driver's license, he probably want to pay that 288. At least get a port of clearances here at 36 District Court. That's the only thing I can see affecting Mr. Gator's license. Mr. Gator, what I'm going to do is I'm going to put you in a breakout room with Mr. Berry. Have a conversation with him. Let us know what you want to do when you come out, okay? What happened to Rico Gator?
Maybe his corporation said he had a board meeting.
He had a board meeting? All right, let's pass it. All right, are we ready on someone, Mr. Gator? Let's go back on the record with Mr. Gator. Mr. Gator, I'm giving you an opportunity to speak with counsel. Counsel, what's your client want to do?
We seek a bench trial date, Your Honor.
Is that what you want to do, Mr. Gator?
Yeah.
March the 10th. Come back March the 10th at 9 a.m., all right?
All right, I got one question, Your Honor. He not gonna be representing me, is he? Because I don't want him to represent me.
Well, listen, Mr. Gator, see, this is how it works. If you want to pick your attorney, you got to pay for your attorney.
All right, that's fine. That's fine. That's fine.
We got another attorney in here. We'll always have 2 attorneys in here on that date, though. All right.
All right.
Best of luck to you, sir. Have a very good rest of your day.
You too.
No, I don't see him. All right, let's keep moving. Gator, Rico Gator.
Yes, I'm here.
Good morning to you, sir.
Good morning, sir. How you doing today?
I'm well. All right, City of Detroit, Ms. Soroki versus Rico Gator, case number SP1281837, counts 1 and counts 2, SP1560726-1, SP1624983-2, SP1643083, counts 1 and counts 2, SP1681232, counts 1 and counts 2, in the state of Michigan versus Rico Gator, case number SX4038098. 82. Appearance for the record, please.
Your Honor, Pauline Soroki on behalf of Mr. Gator.
Mr. Gator, state your name for the record, please.
Rico Gator.
Today is the date and time set for a trial on most of the counts. However, on the SP1681232, counts 1 and counts 2 is set for, we'll call it today the date and time set for arraignment. Purposes of arraignment, Ms. Soroki.
I'm going to waive the form of reading the information, stand mute. I'm sorry, Your Honor, what was that charge?
There was 2 new charges, no insurance misdemeanor and a driving while license suspended misdemeanor.
Thank you.
All right, any officers here on Rico Gator? Officer White, Officer Artez, Corporal Baker, can you put your appearance on the record, please?
Yes, Corporal Artez Baker, Badge 21, Detroit Police Department.
Very well. Good morning to you. Is there Officer Shack? Officer Frederick, Officer White. Shack, Frederick, White, and then was that
Prisblo?
Prisblo, BPRZYBYLO. Okay, hearing no response on those other officers, I do not see any of those officers in the room now. We'll just deal with what we have and then get him an updated offer on the no insurance misdemeanor and the driving license suspended. He does owe another 288 on 1 no insurance proof, amongst other civil infractions. That's the one that's affecting his driver's license. Let's put you in a breakout room with
Mr. Bowman, can you meet me in a breakout room, please?
Yes. Yes.
I'm going to put you in a breakout room, Mr. Gator, with Ms. Soroki.
Yes, sir.
Join the room, please. All right, let's go back on the record with Mr. Gator. You already swore him in. Do you understand, right? For let's say, break. Do you swear or affirm to tell the truth, whole truth, nothing but the truth?
Yes, sir.
Put your hand down. Do you understand the maximum possible penalty for this offense is 93 days in jail and or $500 in fines?
Yes, sir.
You understand that you have an absolute right to a trial?
Yes, sir.
Ms. Soroki went over your other advice or rights in the breakout room, did she not?
Yes, sir, she did.
You understood those rights?
Yes, sir, I did.
You have any questions about those rights?
No, sir.
You know by taking the deal, you're gonna give those rights up?
Yes, sir.
Has anybody offered you anything other than what's been stated in the record?
No, sir.
Which one are we pleading to? Are we pleading to Officer Baker's tickets?
Yes.
Let me draw. Let me draw your attention back to September 24, 2024 at around 12:28 p.m. in the city of Detroit area of last year in Grand River. Sir, did you have an occasion on that day to come in encounter with the Detroit Police Department?
Yes, sir, I did.
Were you operating a motor vehicle?
Yes, sir, I was.
The officer asked you to produce a valid driver's license?
Yes, sir.
What was this? What was this allowing?
Yes.
Well, let's do an improper plate on this, because he wants an allowing and a what? What was the other thing?
There's gonna be one fail to display, one allowing, and one impeding.
So we have, so you're pleading to the new cases then? Allowing.
There should be.
Failure to display. The one ticket with the allowing officer, that was Officer Frederick here. So Officer Frederick, I don't think checked in.
I think Mr. Bowman said he was, I don't know.
Officer Frederick did check in. I have a phone number for Officer Frederick.
Oh, he did check in. Okay, very good, very good. All right, there we go. All right. One allowing, one failure to display, and another what?
Impeding traffic.
All right, on that day, sir, on that day we called, did you fail to stop at a stop sign?
Yeah, yes, sir.
All right, blocking traffic for that, found him responsible. Just for matters of convenience, let's just plead them out to the other two, failure to display and an improper plate amended count. Same effect. Let's say, let's draw your attention back to February 20th, 2025 at 10:03 p.m. in the city of Detroit in the area of 7 Mile and Hubble. Did you have occasion on that day to come in contact with the Detroit Police Department?
Yes, sir, I did. Yes, sir.
Were you operating a motor vehicle?
Yes, sir.
Did the officer ask you to produce a valid driver's license and insurance?
Yes, sir.
You could not, could you?
Can you repeat that, sir? I apologize. Your camera, like your voice went out.
You couldn't produce either valid license or insurance, could you?
No, sir.
All right. Why couldn't you do it? Why couldn't you produce insurance?
At that time, I didn't have it, but my girlfriend just sent me the text. I don't know why I couldn't log in, but I could turn my camera around.
You have it now?
Yeah,
Well,
hold on. I could turn my camera around.
it doesn't.
All right, let me say something. Let me pass the matter. Miss Grant, when I'm telling you, you need to be dressed like you're in court, not at home on your couch. I don't understand why I need to explain that to you. All right, let's go back on the record with Mr. Gator. You want to pass it and see if he's got the documentation together?
No,
I do.
actually,
My girl sent me,
the prosecutor was going to go forward without him providing his insurance, so he's
but
already.
I can provide it for you guys.
Okay,
My
Mr.
girl sent
Gator, Mr. Gator, it doesn't change the deal, okay?
it. All right, I'm just letting you guys know.
Thank you.
All right. Anyway, you couldn't provide it at that time?
Yeah, I did. I couldn't show it at that time, Your Honor. I'm sorry. I couldn't provide it at that time.
And your license was suspended at that time as well?
Current to your officer, yes, Your Honor.
Well, I mean, either.
It was suspended because it was, yes, Your Honor. Yes, Your Honor.
All right, improper plate, find him guilty and failure to display. Here's what I'm gonna do. I'm only gonna fine you for 2. I'm not gonna fine you for the improper plate. And I'll fine you $240 for the failure to display, and I'll fine you $175 for the blocking traffic, all right?
All right, thank you. I appreciate that.
All right, so we'll do it that way.
Thank you, Your Honor.
I was about to say,
So
did you
I
need
can
me
go
to-
to the Secretary of State and pay the reinstatement fee, correct now?
You need to go to Secretary of State and pay this $288 to get your driver's license. I thought I told you that last time.
No,
You know-
when I tried to go get them last time, they told me I had to wait to see what the court or the outcome. I tried. I left your courtroom and went
You
straight
never
to
paid the $280. You never paid the $288.
Okay, I'll go pay the $288.
It has to
I'll
be
go
paid
pay
at
it.
36, not Secretary of State, 36. And then you're going to have an additional 30-day wait on your license because you took that fail to display today. So.
And you're gonna owe this other money. So when can you pay the other money?
How much do I owe in total, Your Honor?
So for today, let's talk about today. I don't know the total. I'm gonna waive the warrant fees as well. Ms. Mathis has to put it in the system. So for today, I'm talking about $240 and $175.
Is that going to give me my license back?
No,
I don't have the money today. Then I'll pay it like next week or the week after that. I don't got it today if it's not gonna get my license back.
what do you mean if it's not gonna get your license back? You're gonna have to pay it anyway. You gotta.
I don't have I don't have it today, Your Honor. I don't have the money today.
You telling me you don't have the money today if it's not gonna get your license back. So basically I can infer that if you was gonna get your license back, then you would have the money?
Correct. I was gonna call my grandmother and borrow the money until I got paid, but I'm not gonna call my grandmother and borrow the money if I'm not gonna get my license back today. Correct, Your Honor. Correct.
Listen, sir, don't get smart with me because it's 93 days in jail waiting on your head. I can just let you do that instead of paying, but I'm trying to help you out so you can get a valid driver's license.
I'm not getting smart with you, Your Honor. I just said if I wasn't getting my license today, I don't have the money today. That you asked the question, I answered the question. I don't know how that was getting smart with you. I answered your question just how you asked.
It's your tone. It's your tone. That's how it's getting smart. Here, let them figure it out. April the 10th, 2025, and I'm gonna mark and file allow payment plan. It's paid by April the 10th, 2025. I'll mark and file allow payment plan. Have a very good day, Mr. Gator. Best of luck to you.
You too, my boy.
Ooh.
Not your boy.
You too, my boy.
Ooh.
Not your boy.
All right, all right, I'm sorry.
This is not the streets. This is not the streets. Get out of the streets.
I'm not in the streets. I go to work every day, 9 to 5. I had to call off to be here today.
Mr. Gator.
He talking about the streets. I don't be in the street.
Well, you sound like it. You sound like it. I'm not your boy. All right. Best of luck to you.
Ryan Ziegler on behalf of the people.
Thomas Seeger appearing on behalf of Mr. Hart.
I have somebody in my hearing room listed as Ryan Hart. State your name for the record, please.
My name is Ryan John Hart.
I I don't have anyone on my docket listed as Ryan John family of Hart. I have an individual listed as Ryan John Hart. That's either you or it's not. You get to tell me whether or not that's your name. If it's not, then I need to call a different matter and bring somebody else into my hearing room.
Your Honor, I'm the representative of that entity, yes.
That's not an answer, sir. Your name is either Ryan John Hart, in which case you're invited to participate in the proceeding today as Ryan John Hart, or you're not Ryan John Hart, in which case I have no use for you to be in this hearing today. So tell me your name so that I can determine whether or not you're the proper person to be called in this case.
My name is Ryan John Hart. May I ask a question, Your Honor?
No, you may not. Mr. Hart, this is not a complicated process, and this process does not get less uncomplicated. When I call a case, I start by identifying the parties that are to the case. When I'm confident I have the correct parties to the case, I proceed then and decide how to go forward. In this case, your difficulty, and I think intentional difficulty, is affecting the ability of the court to be able to proceed and to conduct its business. That's relevant to a lot of points, but most importantly, it's relevant to a pending motion that your attorney filed, presumably on your behalf, but I sense that it's not only on your behalf, it's also on your attorney's behalf. And so we're going to take up that motion. But your difficulty in basic things like telling me whether or not you're the party to a case is thwarting the court's ability to timely get its business done. I'm turning to the motion now that's before the court today, which is a motion to have attorney withdraw and to have you represent yourself, Mr. Hart. The court does not find that motion to be well placed, and I'm not going to prevent it. And the reason is there are several steps that need to be taken in order for you to be able to assert your right to represent yourself. First and foremost, I must find that your assertion of that right is unequivocal. I don't have that. What I have is your attorney's motion, and I recall very clearly and plainly the last couple of hearings that we've had. A couple of hearings ago, I had findings that I made based upon a competency and criminal responsibility examination. You were found both competent and criminally responsible by the court after assistance from the Center for Forensic Psychiatry and after an in-depth intervention and interview by them. I made the findings, your attorney agreed with them, and the prosecutor agreed. I have not once heard you make any type of unequivocal request at all. What I instead heard when I consider whether or not there's an unequivocal request for you to represent yourself is your attorney explained to me, I think this was 2 or 3 hearings ago now, that he was somewhat conflicted. And these are not his exact words, but this is what I recall from it. He was somewhat conflicted. You had wanted him to file various different motions, which the attorney did not find were supported by law. And the communication that I had in response to Mr. Seeger, again, was some version of this. I told Mr. Seeger that as the attorney, he and he alone chooses which motions are to be filed and which are supportable by fact or by existing case law or by the extension of existing case law. If he can't make those arguments that are good faith supported by law or an extension for the law, then he's not permitted to file the motions. It was at that point that Mr. Seeger then suggested that another solve for him could be that you could represent yourself. In other words, the implication that what Mr. Seeger was making is that if you were representing yourself, you would not be constrained in the way that he is. It would allow you to file whatever frivolous motions, I'm using that word, Mr. Seeger didn't, whatever frivolous motions you wanted to. And so the request to have you represent yourself as made through your attorney is not found, number one, by the court to be unequivocal in any way. Number two, I would have to go through with you and be confident that you understood the maximum penalties associated with the crimes. I have every reason to believe that you understand the maximum penalties, but I have every reason to believe that if you and I had a discussion about what those maximum penalties were, you would express confusion and you would not express a knowing, confident, and voluntary understanding of those things. And so I'm not yet even going to get to that second step. I also, of course, would have to, under People versus Anderson, the binding Michigan Supreme Court case regarding waiver of constitutional right to represent yourself, I would have to make specific other findings. And those findings specifically are that I would have to determine after a conversation with you that you acting as your own attorney would not disrupt or unduly convenience or burden the court in the administration of the court's business. What is plain, obvious, and unarguable in over the last 2 or 3 hearings is that if you were permitted to represent yourself, you would make the court's administration of justice difficult, you would delay matters, you would be disruptive, and your representation, therefore, of yourself would be unduly inconvenient to the court and the court's operation of its business. For that reason, even if I found that you otherwise made an unequivocal request, which you haven't, even if I found that you clearly understood and you expressed your waiver knowingly, intelligently, and voluntarily, the court would still not grant your request through your attorney to represent yourself under specific circumstances here. It's my firm finding, based upon the background that I'm aware of, that to allow you to do so would only encourage you to file what are very spurious and frivolous motions. It would waste the court's time, it would waste the prosecutor's time. And although it would waste Mr. Seeger's time to have him remain on, the court also notes that even if there is good cause for Mr. Seeger to withdraw, the Michigan rules of professional conduct allow the court to continue an attorney's appearance and order that an attorney continue on a case even when there's good cause to withdraw. And so I choose to exercise the discretion provided to me under those Michigan rules of professional conduct and the Michigan court rules and Michigan case law in denying any request to have you represent yourself. You are and will remain represented by Mr. Seeger until further order of the court. Mr. Seeger, did you need then some time to discuss the effect of that ruling with Mr. Hart before I decide how this case needs to resolve?
I do,
by way
Your
of trial.
Honor. Additionally, Your Honor,
Here, the push for self-representation creates a strategic problem because the court is not only evaluating the request itself, but whether granting it would disrupt the proceedings. The attempt to gain control ends up becoming evidence against the request.
Your Honor, I have something to say. May I speak?
Mr. Hart, you don't get to decide when things are said. That's again part of the issue.
The judge has not let me speak at all in more than three.
Mr. Hart, this will not be an argument. This case will not proceed by me talking over you or you talking over me. Court proceedings by law and by procedure, Mr. Hart, are to be ordered. And they're to be in a specific order, and that order is dictated by the trial court judge. That's me. It's not dictated by an individual who's charged with criminal offenses, you. And so I'm going to exercise my discretion to control those proceedings. You right now, Mr. Hart, are free on bond. I don't particularly have any care as to whether or not you're free on bond or whether or not you sit next door, except to this point. For today, I'm going to expect that you disagree with my decision on your motion to have you represent yourself. I'm going to therefore excuse any further appearance of you for purposes of today's hearing and today's hearing only. I'm going to set this matter for a new hearing after I hear from your attorney and from the prosecutor. That new hearing is going to be set in person. The reason I choose in my discretion to set it in person is because if you're disruptive or unduly burdensome to the court at the next hearing in person, I'm going to view it as a violation of your bond conditions. And if I view it as a violation of your bond conditions, you're going to be subject to the contempt powers of the court, which includes me revoking your bond and you sitting next door. Because if I have your bond revoked and you're sitting next door, I'll know that Mr. Seeger can locate you and communicate with you. And if you have your bond revoked, I'll know that I'll be able to better control the situation than I can over an electronic communication like we're doing now. Because as you've demonstrated, the only way I can control the proceedings right now is to mute you so that you can't speak over me. That's not an effective way of running a courtroom, but it's the only way that I'm given your attitude, experiences, and your frustration. Mr. Seeger, did you wish to make a responsive record?
No, Your Honor, I do understand the court's ruling and I clearly will abide by it. Be that as it may, Your Honor, and I will discuss this with Mr. Hart. There was an amended offer that was extended, which
can you please speak up so that Mr. Hart can clearly?
Sure, Your Honor. There was an amended offer that was extended, which is much more favorable than the previous offer. I will discuss it with him. He can determine how he wishes to proceed.
All right. Did you want to, for purpose of the record, state that offer on the record?
Your Honor, my understanding is that he could plead to one count of attempted resisting and obstructing, which would be a misdemeanor in lieu of dismissal of the attendant charge together with the habitual offender notice.
What was the habitual offender notice that was charged?
It was I don't have it in front of me, Your Honor, because I just had the motion.
Your Honor, he's subject to a habitual 4. I believe it's on the information.
And I just didn't have the file in front of me, but do you disagree with that, Mr. Seeger?
No, Your Honor.
All right. So, Mr. Hart, it's very important that you not only hear the offer that's been made as an offer to an attempted resist and obstruct charge for dismissal of the existing charge as well as a habitual 4th, but it's fundamentally even more important that you talk to Mr. Seeger about that. He can give you advice. You ultimately get to decide how to proceed, and it does not matter to me how you proceed, so long as you proceed with the understanding that court procedures require structure, and that structure will be followed by you and by anyone else that's in this courtroom, or there will be alternative options considered by the court. Mr. Ziegler, anything further on any of that the people would like to offer?
No, Your Honor.
No, sir.
All right, the court will set this matter for a status conference next month. I will require that everyone in this matter be in person for the reasons I've already explained. Mr. Hart, you're free to sign off now. I expect you'll talk with your attorney and be here in person next month. You'll get a notice in the mail.
Across both proceedings, the same basic lesson appears from two very different courtroom situations. Legal rights still operate inside legal procedure. In Transcript 2, the dispute centered on self-representation and the defendant's repeated effort to control how the case would proceed. The court's concern was not simply disagreement. It was whether that approach would interfere with the court's ability to conduct the case. That distinction matters. A defendant can have a real constitutional right and still be required to follow the rules that govern how that right is exercised. The court specifically identified the requirements for a valid waiver of counsel and connected them to Michigan law and case law. It then concluded that the request did not satisfy those requirements and that allowing self-representation would create additional problems for the court's administration. Transcript 1 shows the practical side of that same principle. Earlier, the defendant's reliance on the corporation versus individual distinction did not prevent the court from identifying the actual person involved in the proceeding. Later, when the case reached questions about licenses, insurance, fines, and payment, the legal consequences were tied to concrete obligations rather than arguments about legal identity. The important change in Transcript 1 was strategic. Once counsel was involved, the proceeding moved toward specific charges, admissions, negotiated consequences, and a payment arrangement. That did not erase the underlying obligations, but it created a clearer path toward resolving them. Both cases show why courtroom strategy matters. A legal argument that increases friction without changing the legal issue can consume time while making the court less willing to accept the requested approach. The strongest position is usually the one that keeps the argument connected to the actual legal question, the governing procedure, and the consequence the person is trying to avoid. In the end, courtroom outcomes are often shaped long before the final decision, by the choices made about how to participate in the process.